Hi, welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about why a Medicaid divorce might be appropriate. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. So in Florida, it's very uncommon for married couples to engage in what they call a Medicaid divorce, which is essentially a couple will become legally divorced even though they otherwise have no reason to divorce. They love each other very much. There's no dispute. There's no reason to divorce, but for the fact that one spouse needs to apply for Medicaid benefits for their long-term care. And the only way to obtain this health insurance is through a divorce, or at least the only way for them to obtain this health insurance and protect some assets is through a divorce, because as a single person, they would be in a better position to be able to qualify for this federal program for health insurance. Normally in Florida, we have a lot of other tools where couples would never need to engage in an actual Medicaid divorce. There's spousal refusal, there's many different tools. But there's one fact pattern where a couple might want to consider it. And this is a unique fact pattern. Essentially, if a couple owns their homestead, which is, protected here in Florida, as tenants by the entirety, meaning, 100%, it's owned 100% by the spouse of each spouse. And one spouse lacks the capacity now to change the way that deed is titled. And if this married couple happens to be a blended family, meaning that they married later in life and they each have children from prior relationships, holding your property as tenants by the entirety means that the first spouse that passes, the other spouse inherits 100%, right? They are the default 100% owner of that property. And now that would essentially could cut out the line of the other spouse, the dead spouse, right? Their children would not have any interest in that family home at that juncture. If it was just a classically held T&E property, then it would go to the surviving spouse's heirs, whatever they name in their will, or if it was intestate, just to their children. So if that happens to be husband and wife own their family home, and the person that does not have dementia, or the person that has capacity happens to die first, so the person holding the interest of the family home is now the person that lacks capacity, so that way they can't make any changes to the deed. There's no changes to your will, so if they didn't have a will, they can't draft one now, and essentially the house then would go 100% to their heirs, leaving the otherwise healthy spouse, but predeceased, cut out, right? So if you were in that position and you were a healthy spouse and realized that maybe you didn't put in place estate planning that you should have before your spouse lacked capacity, now they don't. Now they have no capacity. One way to break up that tenants by the entirety situation that you have with your family home is through divorce, because they don't have the ability to sign a deed. If you went to the guardianship court, you don't know if the judge would allow you to change your the way you hold your interests, because they might, who knows, you're up at the judge's discretion when you're in the guardianship court. But you can force the hand by getting a Medicaid divorce. Essentially, through the divorce proceedings, that title of that property will change, right, to tenants in common, at least as a default. And that's one way to engage in certain sorts of estate planning and why you might need a Medicaid divorce. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And as always, you can schedule a strategy session with me at eldermeeting.com. Thank you.